The effect of an entire agreement clause. In fact, what even is an entire agreement clause? Well, looking at my trusty NEC3, I know it's a little out of date, but bear with me, the same clause applies. It says at clause 12.4, this contract is the entire agreement between the parties. Basically, it sets out that the parties to this contract cannot rely on pre-contract documents, that's the invitation to tender, the tender response, the RFPs, collateral contracts, discussions, pre-contract minutes, as relevant and affecting the contract. So it's in here or it's not in here. It's referred to as a document or it's not part of the contract. See, it doesn't actually withdraw anything you might have said before the contract, but it means it doesn't have contractual effect. You can't void the contract because of it. So in a case called Entrepreneur and East Crown back in 2000, the court said the purpose of an entire agreement clause is to prevent one party from threshing through the undergrowth and finding in the course of negotiation some chance remark or statement on which to bring a claim. The entire agreement clause obviates an occasion for any such search, so that basically, if it's in the contract, you've signed up to it. If it's not, then it's not a contractual obligation. Now, it could be that there are things that you've said that actually you could bring a claim for under misrepresentation, which is a tortious claim. So if somebody makes a statement which induces you to sign the contract and it turns out that they made it negligently, i.e. not caring whether it's true, or positively fraudulently knowing that it's not true, then you can bring a separate claim, but it doesn't necessarily undermine the contract. The one thing that always an entire agreement clause does not exclude, and you might be surprised by this, is something called implied terms. So terms can be implied by custom, by statute, or by cases. And the courts have held on a regular occasion that the phrase entire agreement includes express terms and implied terms. So you can't wriggle out of implied terms that way. However, there is a clause that does allow you to exclude implied terms to the extent you're entitled to under a contract. Some terms are mandatory. Whatever you say, they're going to be in there. Other terms are optional and can be implied where the circumstances allow, but you can avoid it. So this is the MF1 form of contract. This is for mechanical, electronic and electrical plant. And this has something called an exclusive remedies clause. So at clause 44.4, it says the parties intend that their rights, obligations and liabilities are exhaustive of their rights. So if it's set out in the contract, that's fine. It said, except as provided for in the contract, neither party shall be liable to the other in relation to breach of contract, statutory duty, tortious or negligent act or omission. So it also says that there are no remedies effectively for implied terms. So an exclusive remedies contract basically says if it's in here, then you can have it. If you need to rely on some other form of mechanism to get it in, then you're on rockier ground. So entire agreement clauses and exclusive remedies clauses have two really slightly different effects. Entire agreement clauses can be much shorter, but then they might not have the effect you want. There was a case called Access Sun Life where the one of the directors of the company who had written the contract, which had the entire agreement clause, was asked what it was meant to do, and he didn't have a clue. And that's true of most people who put entire agreement clauses in. The reality is that it's really unusual to try and escape liability under a contract because of something that was promised beforehand, unless it's proven to be an outright lie. Somebody has held you to ransom. And that would be entitled to do that anyway, because fraudulent misrepresentation can't be excluded by an entire agreement clause. So think carefully about what goes into contracts. You often see entire agreement clauses go into pretty much all the contracts. I've seen them in framework agreements. Well, a framework agreement isn't the entire agreement between the parties, because a framework agreement requires either a project order or call-off agreement in order to create any obligations at all. So putting entire agreement clauses in needs a little bit of thought. It's not just a simple copy and paste. It's not just it's a simple line, we'll just chuck it in. Think about, does it really apply to your situation? Has it ever arisen as an issue? Or is this just more words for the sake of words? Is it entirely necessary to have an entire agreement clause? keep your contracts simple. Make sure you understand what they say, because if you're ever in the witness box in court trying to justify the wording of your contract, you really ought to know what that clause is meant to do before you persuade everyone else to sign it.